जब तक की टीम्स आती हैं मैं रूल्स दोबारा से क्लैरिफाई कर देती हूँ. Semi-final round will be a ranking round, and top two teams with the highest total score in these oral rounds shall qualify for the final round. The side to be represented by the team shall be determined by the draw clause, with the teams picking the lot after the completion of quarterfinal, which we have conducted yesterday. Now each team shall get a total of 25 minutes to present their case, and the time for return answer is 5 minutes. Any extension of time beyond the specified period shall be subject to discretion of the judges. The division of time So, first of all, there is a draw of lots. Please come one participant from B3 team. Team A4. Team A4. One participant from team A4 side. I request you, B3 and B5 team, one participant from each side, from each team, for a draw of lots. B3 and B5, sir. B3 and B5, it's a kind request. Don't be confused. The teams are B3 and B5. Defense side from B5, right? It's a kind request to judges. Please note down B5 is presenting from defense side and B3 is representing from the prosecution side. Got it? So with the permission of judges, I request B5 team to proceed first. B3 team will proceed first. Judges, please note down. B3 is going to represent from the prosecution side, from the appearance side. B3 team, you have only 25 minutes to present your case and 5 minutes for rebuttal and show rebuttal. So be on time. Yeah, B3, you can start with that.
Hello. Good morning to the respected judges. The council seeks your permission to start with the issue of framing the issues. Your Lordship, before framing the issues, I would like to throw a light on the sections under which the accused has been charged. The accused has been charged under the section 354A of IPC, section 354C of IPC, section 66C, section 354D of IPC, section 509 of IPC, section 66C of IT Act 2000, section 66E of IT Act. Your Lordship, our first issue, whether Mr. Vicky can be held liable for the cyberbullying and harassment endured by Ms. Eliza. According to Indian Penal Code 1860, section 354A, any man who engages in unwelcome and explicit sexual behavior, demands sexual favor, shows pornography against the woman will, or makes sexual colored remarks can be punished with imprisonment or fine. And as per the facts of the case, Ms. Eliza received direct messages containing certain violent explicit images of herself. The content was not only derogatory but also a malevolent assault on her dignity, leaving her emotional scared. According to IPC Section 354C, any man who watches captured images of a woman, private act, or disseminates such images without her consent can be imprisoned for 1 year to 3 years on first conviction and 3 years to 7 years on subsequent conviction. And as per the facts, the police determined that the pictures are created through AI technology. According to Section 354D, monitors the use by a woman of the internet, email, or any other form of electronic communication commits the offense of stalking. Section 509, whoever intending to insult the modesty of any woman utters any word, makes any sound or gesture or exhibition. And as per this statement, Vicky got into a disagreement leading to altercation. That was a motive with him for doing such act. This may have happened because Vicky had also applied to the same institution but did not get the offer. As per Section 66C of IT Act, whoever prudently or dishonestly make use of the electronic signature, password, or any other unique identification feature of any other person shall be punished with imprisonment. Section 66E, punishment for violation of privacy. Whoever intentionally or knowingly captures, publishes, or transmits the images of a private area of any person without her consent under circumstances violating the privacy of that person. Your Lordship, explanation for Section 66E. Transmit means to electronically send a virtual image with the intent that it be viewed by a person or persons. And as per the statement, Vicky has sent the image on hacker to Miss Eliza. Capture with respect to an image means to videotape, photography, film, or record by any means. Your Lordship, to justify my statement, I would like to refer to the case State of West Bengal versus Amish Bakshi 2018. The accused had the victim's phone and took control of some of her private pictures. He blackmailed her by threatening to post those pictures on a pornography website. The second case that I would like to refer is Vishaka versus State of Rajasthan, AR 1997. And in that case, the Honorable Court described that modesty of a woman was clearly destroyed, and it is humbly submitted before Supreme Court of India that the expert opinion should not be reliable. Expert evidence is only a piece of evidence and weight to be given to it and to be just along with other evidences. Your Lordship, on the question of statement by tech expert, as a tech expert Vinny has said that the wiki's system was being hacked. To justify that statement and to cross that statement, in the landmark judgment of Mohammed versus State of UP,
Carry on, please.
in the landmark judgment of Supreme Court, Mohammed versus State of UP, it would be highly unsafe to convict a person on the sole testimony of expert. In the landmark judgment of Gopala Reddy versus Statement of Andhra Pradesh, the Supreme Court held that an expert evidence is a weak type of evidence. Court do not consider as conclusive and therefore it is not safe to rely upon it. In the Kumar versus Whitley, authorities, hello. The additional chief metropolitan magistrate of Chennai sentenced N.C. Arun Kumar, the accused, to undergo business imprisonment of 1 year with a fine 5,000 under section 420 IPC, cheating and 66 of the IT Act. And another case I would like to refer of Kamla Kanta Tripathi and versus respondent, State of Odisha and others. In this, the accused was held liable under section 66 of the IT Act. Masking his own identity, the Supreme Court observed that the culpability of hacking depends on the presence of mens rea of the object with which the act was carried. And Vicky was having a mens rea as he was not selected in the Stephens University, but Miss Eliza was selected. Your Lordship, I would like to refer some other cases relating to the hacking because in the modern world where technology is growing rapidly, the cases of hacking are also increasing. Some celebrities' accounts were also hacked in a certain manner. Amitabh Bachchan's account was also hacked and his picture with Pakistan's PM Imran Khan was posted. Deepika Padukone's account was hacked in December 2020. Noora Fateh's account was also hacked. Shahid Kapoor's Twitter account was also hacked in 2019. Your Lordship, issue number second, that the question is raising whether the age of Mr. Vicky warrants special consideration for him and should he be regarded as a juvenile or an adult in these legal proceedings. Your Lordship, according to the JJ Act 2000, Section 15, in case of a heinous offense alleged to have been committed by a child who has completed or is above the age of 16 years, the board shall conduct a preliminary assessment with regard to his mental and physical capacity to commit the offense, ability to understand the consequences of the offense, and the circumstances in which the alleged commitment the offense. Your Lordship, to support my statement, I would like to refer a case of Mukesh and others versus Union of India and others, AIR 2017, also known as Nirbhaya rape case. That the accused age should not be used as a shield for the level of cruelty perpetrated on the victim. It is observed that he physically abused the woman with a mental bar. In the last sentence, the young man was released after serving his prison sentence by court. In another case, Prag Bhatia, juvenile, through legal guardian, State of Uttar Pradesh, 2016. The respondent in his case was arrested for murder and imprisoned in a juvenile home. Your Lordship, I would like to also reference another case, Jean Fast Track Court on 18th of April 2014, just 5 days before, has convicted a juvenile at 20 years of imprisonment. The accused was Parveen Kumar. He was a sportsman. In another case, in Ram Prasad Sahu versus State of Bihar, AIR 1979, that a minor criminal can be convicted of both rape and attempt to rape if a youngster is not eligible for punishment but is capable of committing rape or murder, granting him blanket immunity, violating principles of fairness and proportional of punishment. Your Lordship, also as per international conviction USA, in the USA, anyone 13-year-old and above can be tried as an adult if he or she has a record of previously breaking the law or committing a serious crime. Children between the age of 15 to 16 are tried as adults for certain offenses like murder, aggravated criminal sexual assault, and armed robbery with a firearm. Your Lordship, with your due respect, I would like to uh, call my co-counsel for the further proceedings.
Your Lord, I would like to seek your permission to cross the line. Thank you. Good morning, Your Lordship. Your Lordship, I would like to seek your permission to further proceed the statement of issue. Issue number 3. Whether the penalty imposed on Mr. Vicky is justified and legitimate. Aliza is a girl of bright mind and is in a tender age of she is suffering a social embarrassment which is a further has caused her mental cruelty. In the images has trans she is thus scared for life. Vicky did this deliberately and the further committed this shameful acts compromised the under IPC ITA. After looking upon these facts and circumstances, the subordinate court and high court decided in favor of Aliza and the convicted the accused under section IPC and section ITA, section number 66C and section 66E, thereby imposing a 10-year sentence on Mr. Vicky. So penalty imposed on Mr. Vicky is justified and legitimate. Your Honor, I would seek your attention toward this important point. Point number 1. Psychology and emotional impact. As stated by Eliza in her statement to investigate and Vicky's action caused her loss, her emotional and break into prosecuted acts. Psychological emotional impact. Whole sequence for victim include depression, anxiety, for low estimate in suicidal thought, sin appellant, the teenager, see particular. See more the vulnerable and the effect of cyberbullying. Your Lordship, educational impact. Cyberbullying is reputed and Eliza education causing a miss school experience, decline the academic and even the thought for exchange in a learning environment. Social isolation. Aliza has been withdrawn the social activities and relationships and social isolation further the emotional distress. IP address. As the accused, the system was Your Lordship, I would like to refer a some case like Medika Gandhi versus Union of India. In this case, Supreme Court held the right to life not merely a physical right and include within the ambit right to life and human dignity. I would like to refer a second case, Jija Bose versus Union of India. It is also related to human rights and human discrimination and harassment. Issue number 4. Whether the victim's fundamental rights of privacy has been breached in investigation, his system was looked without his knowledge and permission. whether the investigation should be set aside on aforesaid ground. It is humbly request to Honorable Supreme Court to privacy should be sealed accused if even investigation against the accused come under the privacy and if examined with her permission. I would like to refer a case Kharak Singh versus the state of UP. In this case, main issue preventing the suspects put some restriction on the rights of privacy. Another case I would like to refer the K.S. Puttaswamy versus Union of India. Another case it is one right of privacy was recognized as a fundamental right given under the Constitution. Your Honor, I would like to last case refer Dipti Kuwar versus Punam Julka. In this case, fundamental rights of Constitution is isolated and conflict with two fundamental rights. Thank you, Your Honor.
Now I request Team B5 to present from defense side. You have only 25 minutes. Please try to cover within a time limit.
Good morning, sir. The council here represents the case for respondents. My team code is B5. As you are already familiar with the facts of the case, my friend, I would like to straight away start with the summary of arguments. The first issue here is whether Mr. Vicky can be held liable for the cyberbullying and harassment endured by Elisa. It is only submitted before the Supreme Court of India that the appellant is liable for cyberbullying and the harassment endured by Miss Elisa because under the investigation, which was done by the investigation officer, Mr. Kapil Sabha, in the initial probe as well, the IP address was tracked and it was clearly visible that the computer system which was used to send the messages and as images talked about here, it was through a computer system which was owned by Mr. Vicky only. And cyberbullying should be considered as a heinous crime because it can lead severely even to the suicide of the victim because it just flashes the future of the victim also, and in the society also she can't be just roaming around like freely in the society now. Also, I would like to quote some of the case laws. The case of Prakash Sharma versus State of Madhya Pradesh. Case number 2. Herein, the accused created a fake Facebook account of the victim and posted some vulgar messages on it. Also, along with the photos and victim downloaded from her original Facebook account. The accused was charged under Section 66C, 67, and 67A of the IT Act, where the accused applied for bail also, but it was denied by the Madhya Pradesh High Court. I would like to quote Section 354D of IPC as well, which when a man follows a woman and contacts her, who tries to contact her or to stimulate personal interaction frequently, even when she shows a clear intention of her disinterest. Also, in the case of state of West Bengal versus Animesh Boxi, the accused hacked the victim's phone and took control of her some private pictures also. He blackmailed her threatening her to post those pictures on a pornographic website. Here, the court held that the victim has suffered from virtual rape. It should be noted that the court also introduced a new term in the society of virtual rape, and the accused will be convicted under Section 354D of the IPC. I would now like to proceed to the issue number 2, Mayor. Whether the age of Mr. Vicky warrants special consideration for him to be treated as a juvenile or an adult. Here, I would like to quote sections of CRPC as well. So it is humbly submitted before the Supreme Court that appellant should be treated as an adult in the present case because sending explicit images. So sections CRPC. Yeah. So as per section, I don't know. I just basically, as per schedule 1 of the CRPC, they are the list of the IPC sections which are considered to be cognizable offences, and these are serious in nature. I was talking about that, sir. Sorry. In the case of Mukesh and another versus State of City of Delhi and others, case number 7. Herein, also known as the Libya rape case, the accused age should not. The court stated that the accused age should not be treated as a shield for the level of cruelty he perpetrated on the victim. It was observed that he physically abused that woman with a metal bar, causing her pain also. And in the last sentence, the young man was released after serving his prison sentence by the court's decision. Also, in the case of Parag Bhati juvenile through legal guardian versus State of Uttar Pradesh, case number 8. Respondent in this case was arrested for murder and imprisoned in a juvenile home. Also, as per the International Conventions, USA,
I again repeat that B5 team is from defense side and the other team B3 is from prosecution side. Your team is from defense side.
They are demanding acquittal of accused.
Yep.
You are demanding acquittal of accused.
it's an appeal. It's an appeal, sir.
It's an appeal.
Appeals.
And appeal में appeal can't do होता है वो defender accused को defend करता है.
Accused को defend.
But in your prayer clause it is clear. या ऐसे आपने तो ऊपर clear नहीं किया. अपील में prosecution जो होता है जो applicant है फिर जो कि आप जो हमारे पास फॉर्म उसके अंदर applicant और respondent है. जो अपील में applicant हमेशा accused होता है. कि वो अपील करता है कोर्ट में defense से इस communication.
I am from the state side.
Yeah, you
I
are
will be convicting the appearance side. Sorry.
you are
No, sir. I'm the respondent, sir.
Really? What do you want from us?
So I want that to uphold the judgment.
But you played your prayer is appellant can kindly be acquitted in the light of aforesaid appealing and trust of justice. And what do you want? We are from the state. From the state, you also want to commission conviction. They also want to commission.
They have to play as a defense. You have to protect the accused.
Both are demanding conviction. Both are demanding conviction.
Yes.
It's a yes. That's okay. It's a mistake when
Both are demanding conviction.
Sir, as per the draft, we have got
who filed the appeal, first of all?
Everybody wanting appeal, sir.
Hey, I said who filed the appeal from the accused side. Either you filed the appeal, you also want to file the appeal. Then who is the lawyer from the accused side?
The case is well proved.
There is this. There you are.
To be starting with raw floats for the instances.
You are the from the prosecution side.
No, sir. Respondent, sir. Respondent, sir.
You want to prosecute the accused. You want conviction.
Yes, sir.
Conviction. So, does it present is a
Yes, yes. I would like to sum up with the. Hello. I would like to sum up my issue with saying that appellant is 17-year-old, but he was aware what was right and what was not right for him. And Honorable Subordinate Court also and Honorable High Court of Andhra Pradesh also convicted him. And the appellant was well known about the consequences of his act, and he should be the sentence should be upheld. And also, I would like to suggest that some of the IPC sections like stalking also say that the provision of the fine as well. So I would like to, in addition to the conviction as well, I would like the court to impose some of the fines to Mr. Vicky, so that my client, Mr. Lisa, should get proper justice. And I would like the council to proceed to the issue number 3 and 4.
With your permission, I would like to start with English number 3. So the issue number 3 is whether the penalty imposed on Vicky is justified and legitimate. So it is humbly submitted before the Supreme Court of Indonesia that the penalty asserted of appellant is reasonable and justified to uphold true vindicate to the matter. The penal sections imposed over appellant are section 354A, 354D, 509 of IPC, and section 66C and 66E of IPL. So I would like to give a brief of what these sections are about. So the sections of IPC 354D is about stalking, and 509 is about word, gesture, or act intended to insult the modesty of a woman. And 354A is about sexual harassment, and the punishments are given in this.
Okay, this whole arguments. आपने just बिल्कुल बोला 354A और 354A सेक्शन किस लेवल पे आपने आप लोग प्रोपोजिशन होगी उसमें कहाँ 354 किस प्रोपोजिशन की
So 354D is about stalking.
इन प्रोपोजिशन कहाँ ये आया है कि वो विकी को बताओ कोई जगह उसको नहीं मिला
Sir, may I be bilingual? May I be bilingual? Like मैं हिंदी में भी explain कर सकती
yeah
थैंक यू। सो जो मिस अलीजा है उनके पास पहले से भी मैसेजेस आ रहे थे फेक अकाउंट से और उसके बाद पिक्चर्स उस अकाउंट से भेजी गई है उनके पास वो मूट प्रोफेशन में मेंशन है। सो स्टॉकिंग मींस लाइक किसी को फॉलो करना।
आईटी से तो नहीं बोल रहा था उसको, वो तो नहीं कर रहा था।
सर दैट आल्सो एक्सप्लेन स्टॉकिंग, मतलब वो चीज को भी हम स्टॉकिंग कंसीडर करते हैं
हाँ,
क्योंकि फेक अकाउंट से बिना आइडेंटिटी रिवील किए वो मैसेजेस कर रहा था दैट विल कंसीडर्ड अनकंफर्टेबल बाय मिस अलीजा।
Electronically also we stop person by messaging one messages also, and from the same account the explicit images were sent. So that's why we are proposing the action of the social.
Answer 354A is about sexual harassment. So Vicky said Vicky by an account sent those images of Aliza to her.
don't you think section 500 of IPC is also affected in this case? You know section 500 of IPC.
So
Defamation.
No, the defamation तो वो होता है ना कि अगर पब्लिक में किया जाए, this was a private matter.
Okay, some of the statements are recorded during investigation.
Yes.
Under which section of CRPC these statements are recorded?
So
It's okay, so.
So cyberbullying, it is a serious crime, and
And they argue that you are here. Email leak. Under which police?
No, so since CRPC I was saying about the cognizance of the crime, I was saying the seriousness of the crime. Actually, that's
So under July, किया जाना चाहिए नहीं किया जाना चाहिए वो किस सेक्शन में है?
so
किस एक्ट में है?
sir, do not decision to come.
So the expert has clearly said that this account has been hacked. So why should he have been held guilty?
so later on another investigation को वहाँ पे doubtful था, उसमें मूट प्रोफेशन में भी लिखा है कि investigation है वो doubtful है, और हमारे पास reference देने के लिए केसेस है जिनमें लिखा है कि expert का opinion नहीं matter करता है 100%.
But it is so आपने कहा वो doubtful
Yes.
doubtful उसको doubtful के लिए conviction होनी चाहिए in doubtful situation. तो क्या है? हम doubtful situation पे rely कौन कर सकती है कोर्ट?
So अब थोड़ा दोबारा explain कर सकते हैं.
Doubtful situation पे courts rely कौन कर सकती है? You said that investigation was doubtful, then you are very guilty. ठीक है, please. Thank you.
So
Yeah.
so we have many cases जो हम refer करना चाहते हैं.
It's okay. I agree with your argument. It is sorry for that. I think this communication आपके बीच में हुआ या आपको नहीं समझा पाए. आपने ऐसा आर्ग्यू किया कि इसको but as before आपको डिफेंड करना चाहिए. प्रोसीजर नहीं करना. पहले पार्टी ब्लॉक कर दिया. No, this is as per law, what they
Sir, sorry for interruption. Actually, I request you, if you want to give 10 minutes from B5 team, so that they can present as a defense side, because they have defense side and they are from prosecution side. So there is a misunderstanding between.
जो निकाला था उसमें दोनों क्या क्या सेट थी.
This side team prosecution and this side. So later miscommunication.
Exactly.
appeal का प्रोसीजर करेगा तो आपको
जब आपने रोल किया था तो इनको क्या दिया था प्रोसिक्यूशन किसने दिया एप्लीकेंट एंड रिस्पोंडेंट. आई थिंक प्लीज दैट इज व्हाट.
Yeah, applicant and respondent, they are from applicant side and they are from respondent side.
अपील के अंदर एप्लीकेंट कौन होगा? आप भी मुझे बोलिए अपील के अंदर एप्लीकेंट कौन होगा?
Prosecution and defendant, P and D.
Yeah, it's our mistake. Sorry for that. And you are from applicant side and that's from respondent side. So
on this list it was written next week and
That clearly says that you are
Yes, sir. Yes, sir, but we are
मैनेजमेंट जो है आप अभी मुझे डिसाइड कीजिए कि आपने इसको वो क्या क्या दिया गया यू अनाउंस जो आपने किया था V3 is applicant and we like respondent. As per अब इस proposition में they are the right to the right vote. If respondent है तो like proposition को प्रीमियर करें. अगर applicant है तो वो अपील को केस में अपील applicant को no, this is announced. Applicant and respondent. Prosecution and हमें तो फाइल they are not how can we say that they are on the wrong side. You are ready for it? Yes. You are ready for it? We gave them. Yes. We gave them. Please.
So now we have to speak from Aiza's side.
Yeah. Defense side. 50 seconds. You want some time? 5 minutes to prepare yourself.
Madam has spoken first and then they also have spoken.
They argue for the prosecution. They are arguing. Now you have to defend quickly. देखिए टेक्निकल उसका आपको मैंने बताओ कि सुनेगी एप्लीकेंट डिफरेंट एप्लीकेंट उसके अंदर दे आर ऑन द राइट अब इन्होंने ड्रॉ की प्रोसीजर और वो निकाला है वो हमें मैसेज नहीं हुआ आगे आप एप्लीकेंट और रिस्पोंडेंट प्लीज सर ये डॉक्टर पानी दिया Please continue.
the council would like to proceed with statement of jurisdiction. The period has approached the Honorable Supreme Court of India. Pursuant to the decision by Honorable High Court of Uttar Pradesh, the court's jurisdiction is invoked under Section 134A of the Constitution of India. The applicant humbly submits this memorandum in pursuance of appeal filed before the Honorable Court. The appellant will act in accordance with the findings and decision of the court. So, sir, first I would like to proceed with the synopsis of the facts. May I, sir?
Yeah.
So, the appellant, Mr. Vicky, his age is 17, and Miss Aliza, her age is 19. Being the victim of the concerned case, State of Uttar Pradesh versus Mr. Vicky, studied at Howard High School, Mani. Both the said parties were good friends till September, but because of a heated argument 6 months ago, they parted their ways. So the incident happened on January 14, where Miss Aliza received some direct messages on her social media account Hacker. Those messages contained violent, explicit images of herself from a fake account, leading her to emotional distress. On the same day, she informed her parents about the occurrence and they registered an FIR in Mani police station. So now I would like to mention the sections for the cases. Section under IPC 354A, 354D, and 509, and sections under IT Act are 66C and 66E. So now I would like to start with the issues. So issue 1 is whether Mr. Vicky can be held liable for cyberbullying and harassment by. So it is most respectfully submitted by the council to the honorable court that the concerned incident, which happened on January 14, where Miss Aliza, age 19, received some direct messages on her social media account containing her violent, explicit images on her social media account named Hacker. The incident traumatized the victim and left her emotionally scarred. The council hereby agrees to the fact that Ms. Aliza has endured the cyberbullying act and harassment, but the main question which arises here is whether Mr. Vicky should be held liable for the said offense of cyberbullying and harassment or not. So the council would now like to draw attention to certain aspects of the case, which will enlighten the honorable court to understand the position of the client in this case. So I would like to start with the tech expert's opinion. So the first thing which is submitted is that appellant's social media account were maliciously hacked, which is further clarified by the police investigation through witness number 3, Miss Winnie, a tech expert, where she analyzed the digital trial and asserted that Vicky's social media accounts have been a subject of hacking attempts and the same were compromised through a phishing attack. For the reference of the honorable court, I would like to quote the meaning of this term used herein by tech experts as per one of the prominent tech brand IBM, a website. So, sir, it is on the page number 1, and the types are mentioned on the second page. So, it's a social media phishing. It employs various capabilities of a social media platform to fish for members' sensitive information. Scammers use the platform's own messaging capabilities, for example, Facebook Messenger, LinkedIn Messages, Twitter, DM, etc. So this evidently states that there is a short possibility that Vicky's device was hacked and were intended home to malware and cast a reasonable doubt over his culpability. Now, I would like to quote section number 45 of Indian Evidence Act, which says that when the court has to form an opinion upon a point of foreign law or science, or art, or as to identify of handwriting or finger expression, the opening upon the point of persons specially skilled in such foreign law, science or art, or in question as to identify of handwriting or finger expression are relevant facts. So now I would like to refer a case, State of HP versus JLR and others, since case number 1. So it lays down that when the court has to form an opinion related to science, the opinion upon that point of person specially skilled in the science and technology is a relevant fact. The court cannot form a correct and right judgment without the help of a person with special skills or experience in a particular subject. So the opinion given by a third person is considered as pertinent facts if the person testifying an expert, and in this present case, Ms. Winnie, who is a tech expert, expertise in technology, so her expertise is used by the respondent. Also, sir, in his witness, the appellant asserted that not only Aliza, but some of his other friends also received some messages from a fake account, on which witness number 4 seconded his witness. And so in the landmark judgment, State of Maharashtra versus the Moot, son of Gopinath Shinde and others, says case number 2. So the Honorable High Court held that without inspecting the expert as a witness in the court, no reliance can be placed on an opinion alone.
And Vicky claims that his social media accounts were hacked and that he was not responsible for the explicit and malicious messages sent to Miss Aliza. If it can be demonstrated that there were hacking attempts on his account and that his account were compromised, this could suggest that someone else was behind the cyberbullying. Vicky also claims that his privacy was invaded when the police officer gained unauthorized access to his computer system to extract information from his social media account.
In proposition, ये mention कहाँ है कि और उसके friends को भी message आए.
So ये witnesses वाले part में information. The researcher will provide me the information. And also, sir, I would refer the witness statements. Witness 1, 2, and 4, that is Saina, Dr. Anish, and Mr. Karthikeyan. All three these couldn't provide the IO with any conclusive assertion that appellant had a character of such violent tendency that he would do any such act of harassing and cyberbullying with anyone whatsoever, nor did they see the appellant perform the act for which a client was impulsively accused of. So, henceforth, Honorable Supreme Court of India may set aside the inquest judgment of Honorable High Court of Uttar Pradesh and learn trial court. So, with your permission, I would like to start the issue 2.
Yes, you make it.
Issue 2 is whether the age of Mr. Vicky warrants special consideration for him and should he be regarded as juvenile or an adult in these legal proceedings. So it is humbly submitted before the Supreme Court of India that appellant should not be regarded as an adult in the legal proceeding. The subordinate court and Honorable High Court did gross injustice with him in this matter by rejecting appellant to be treated as a juvenile, but it is clearly unlawful. On the fact that appellant had disagreement which resulted in altercation of their friendship, it shall not have been enough grounds for considering. Appellant had any intent to perform actions which subject him as offender. Since according to the facts, which also stated by witness 2, Dr. Anish, who is mental health counselor at Howard High School, Mani.
You said that treating major is totally unlawful, but there are numerous judgments. Even a 16-year boy is treated as a major in many cases.
So I have cases here.
And Dr. It is corroborated by the evidence that Dr. Anish, who is mental health counselor, we also said that he was mature of his age.
Yes, sir. He did. But he is mature of his age and he knows what is right and wrong. And witnesses also say that Mr. Vicky will never do such an act. The witness is also saying, and Dr. Anish is saying he's mature.
About the majority of the juveniles. I'm not saying that he can do or not.
So, sir, I would like to refer case number 7, which is Salil Bali versus Union of India and ANR. It was discovered to amend the juvenile justice law present and to deduct or reduce the age from 18 years to 16 years, to amend the juvenile law in such a way that juveniles who have committed the heinous offences like sexual assault and murder should be tried as an adult. But the Supreme Court rejected the plea and held that the Juvenile Act is based on sound principles and with compatibility to the Constitution of India, and also Supreme Court asserted that Act is to provide rehabilitative and restorative mechanisms and help to juveniles. The age of 18 years has been decided on scientific and physiological grounds that until this age, juveniles can be reformed and restored back into society. Also, sir, the case of Mukesh and ANR versus State of NCT of Delhi and others, it is popularly known as the Nirbhaya case. It is case number 8, sir. The apex court refused to grant the harsher punishment on account of his heinousness of the conduct and tried him as a minor. One of the rapists was minor at the time, which gave him security from the harsh punishment. So, in that serious case, he was not treated as an adult. So, how can we treat him as an adult here? So, it is clearly shown that High Court did injustice with appellant by declaring appellant as an adult and it is humbly prayed to Honorable Supreme Court to not to treat appellant as an adult. So the council now seeks permission to continue with the case of the conference.
So I would like to continue with the issue number 3, which says as whether the penalty imposed on Mr. Vicky is justified and legitimate. That since applicant haven't attained the age of 18 years at the time of the incident. Also, as per the sections 2 clause 9 and 2 clause 33, the heinousness of the crime which defines in the section 2 clause 33, it says that any offense in which the punishment is 7 years or more. But if you see all the charges against my client, like section 66C and 66E of the IT Act, as well as the sections of IPC which go under 354D, 509 and 354A. Also, my learned friend applied the
Let's do both of them.
also my learned friend suggested that the charges of 354C is also applicable. But I would like to suggest that I would like to contend that section number 354C is just not applied in this situation because if you read the bare language of the Act, section 354C says that any man who captures or watches any woman indulged in a private act, which was not the case in this incident in our Moot proposition, and it is highly contended that this section should be classed in the present proceedings only. Also, I would like to quote the Convention of the Rights of the Child, CRC. Herein, on the page number 2, Article 1, for the purposes of the present convention, child means every woman which is below the age of 18, unless the law applicable to the child majority is attained earlier, before the incident. Also, in the Article 37, state parties shall ensure that no child shall be subject to torture or other cruel or inhuman or degrading treatment or punishment. Issue number 4 is whether the Vicky's fundamental right of privacy has been breached. I would like to say that the crime which he is charged of is not as heinous as to be treated as an adult, and his social media accounts also and the computer system was taken away by the access was taken away by the investigation officer without his consent. They should have asked the victim, asked the accused, and then took the investigation further. Also, in the case of Mohammed Ali Mubin State of versus State of Assam, case number 13.
Is the accused then denied for the same that he doesn't want to give the access to his social account hacker? Then what should the accused do?
Any party, sir?
If the accused has denied to give the access of his social accounts, then what should the investigation officer should do?
So, if we say that it was denied by the
Let's clear. Accused ने deny कर दिया कि वो social account नहीं देगा और ना sample देगा कुछ देगा. Then basically you have to investigation.
yes, sir. For that matter of fact, sir, investigation officer has the right to forcibly take the investigation further.
For under which provision? Evidence Act, IPC, CRPC.
So CRPC answer. I would like to, if you want to actually explain. So, in the chapter number 7 of the CRPC, information to the police and their powers to investigate. I would like to quote in the section number 154, information in the cognizable cases. If we say that the accused might have rejected the provision of any evidence to the investigation officer, if he so asked in the hypothetical condition, then this crime or this act should have made the investigation officer. Yes.
Please read out. Please read out 154.
So I would like to quote section 154. Every information relating to the commission of a cognizable offence, if given orally to an officer in charge of a police station, shall be reduced to writing by him, and under his direction shall be read over to the informant.
Our very was that he, without permission of the accused, yes, investigation officer take the samples for the case. Clear. It's okay. It's okay. It's okay. We give them a habit of yeah. Yes, as we see, the crime is not such heinous. Why should he not be treated as juvenile? State has treated him as a major. Why should not he be treated as juvenile?
Your Lordship, as per the Dr. Anish, he was a mature boy, and also per his friends, he was at a mature age.
It is explicitly written in the Act, Juvenile Justice Act, that a person who completed the age of 18 is only treated to be as a major. Then what is the very purpose of this act?
Your Lordship, I would like to refer our case, Ashok Kumar versus State of Haryana, in which the accused was just 17-year-old, and also in a case of Ajmal Kasab.
ये जो जजमेंट दिया आपने, ये किस सेक्शन के अंदर इसके ऊपर ट्रायल होता है?
Surrender murder.
हमने क्या
Sir,
जब
the
क्राइम हीनियस नहीं है, उसको डिमाइज क्यों नहीं किया?
so the point we are highlighting that for the fair justice, the age should not be the same behind it.
सेकंड जो एक उसमें था कि अगर उसके हैक किया गया उसको सिस्टम वो रिलायबल नहीं है तो इट इज डाउटफुल और अगर डाउटफुल सिचुएशन है तो जो बेनिफिट है वो एक टू मिलना चाहिए.
Your Lordship, we have 2 points on the point. We would like to refer the page number 10 of our memorandum. Last third line. Elijah on his statement on 24th January. Miss Eliza on the same day told to the police officer that the images he received had some info that only Mr. Vicky was prior about. So, sir, if the account was hacked, then how the third person would have that information? And Your Lordship, the second point, I would like to highlight that the IP address in hacking, the IP address can't be gathered because as per IP address are unique identifiers that allows different machines and network to communicate and exchange information. It has a specific number that cannot be hacked. The number will remain same. So there are the 2 points that define the fact that the system was not hacked. And Your Lordship, on the point that whether the investigation officer can investigate without his
Just in one line, which section?
So, for the matter of fact, the section number 165 already is taken. Search by police officer. Whenever an officer in charge of a police station or a police officer making any investigation has reasonable grounds for believing that anything necessary for the purposes of the investigation and offense which he is authorized to investigate may be found in any place within the limits of the police station which he is in charge or to which he is attached, and that such thing cannot, in his opinion, be otherwise obtained without undue delay. So, if the accused might have refused to provide any evidence,
So it implies that we will take that section.
so but only after asking him and then he rejects the.
Once if I accept that it premises, not for the sample. It's okay.
So, can I oppose the 2 points which were identified?
You are nervous, so there will be this confusion of that. What is the-
Thank you so much, team B3 and B5. Now I invited team A4 and team B2 is with us online.
Good afternoon, ma'am. मैम टाइप करना ना ऑडिबल एक लेट क्वेश्चन की ये वाला लिंक ज्वाइन करना साइलेंट
Hello, am I audible team B two?
Yes, ma'am.
Okay. You are not audible. Can you please turn on the voice?
We have already unmute, ma'am. We are still not audible. Good afternoon, ma'am. Are we audible now?
Hello. Hello, P. Hello.
Good afternoon, ma'am. Are we audible now? Am I audible, ma'am?
Yes, you are audible now. Welcome team B2. Now we have one participant from team A4 and I request the Rohit sir to please comment the draw coach.
Just लिखना है इनको हमें कम होगा बहुत कम है
Team A4 from responding side.
कुछ अलग है साइड
So team B2 from appellate side and team A4 from responding side. Team will start now and you only got 25 minutes. So please try to cover up your presentation within the time limit. Team B2, please start. You all from the appellate side, I again repeat.
Team B2 seek permission from Honorable
You are representing the accused side, appellate side.
Council seek permission to begin with the issues.
Yes, start please.
Council seek permission to address honorable judges as my lord. Council seeks permission to state the facts.
Yes, please.
Much obliged. Bani, a coastal metropolitan city in India, is also known for its rapid development and Howard High School, a prestigious institution with a history of academic excellence. The victim, Miss Aliza, a 19-year-old student at Howard High School with a reputation for intelligence, generosity, and compassion, served as the school prefect for 2 consecutive years. On January 14, 2024, her world was changed. The incident: Miss Eliza received explicit images, malicious images of herself through direct messages on her social media account. Legal action: Miss Eliza, deeply disturbed by the incident, informs her parents and then filed the case against the accused. Investigation: Inspector Mr. Kapil Sharma led the investigation. Initial investigation revealed the images were created using AI technology. Traced the IP address led to the police to Mr. Vicky, a 17-year-old student who was studying at the same high school. Digital evidence: Tech expert Mr. Vinny analyzed Tech expert Mr. Vinny analyzed digital trail and discovered evidence of hacking attempts on Mr. Vicky's accounts. Vinny further identified the use of AI generated content to create malicious images. Lower court ruling: Both the subordinate and High Court of the Andhra Pradesh rejected Mr. Vicky's claim and punished him with 10 years of imprisonment. Council seeks permission to address issue number 1.
Yes, please.
Much obliged. Issue number 1 states that whether Mr. Vicky can be held liable for cyberbullying and harassment endured by Aliza. We stand before this esteemed court on behalf of Mr. Vicky, the appellant in this case. Mr. Vicky is a 17-year-old student who is falsely accused of cyberbullying Miss Aliza. The lower courts convicted him based on circumstantial evidence and statements gathered during the investigation under Section 161 of CRPC, which is not admissible under Section 162 of CRPC, Code of Criminal Procedure, and might have discarded the social fact pointing towards his innocence. This argument will demonstrate that the Mr. Vicky is not liable for cyberbullying. We will address the prosecution's claim, highlight the limitation of the evidence, and emphasize the possibility of hacking incident compromising Mr. Vicky's account. The prosecution preliminarily relies on the traced IP address linking Mr. Vicky's device to the messages. While this might seem incriminating, it falls short of conclusive proof. Digital footprints can be easily manipulated in today's technological landscape. A compromised system or malicious third party could have used Mr. Vicky's IP address. This is a case of hacking, not a cyberbullying. Mr. Vicky has consistently maintained that his account was hacked. This claim is supported by the findings of tech expert Mr. Vinny, who identified the evidence of hacking attempts. The prosecution dismissed the hacking claim without a thorough investigation. The possibility of phishing attack or unauthorized access to Mr. Vicky's accounts needs serious consideration. Furthermore, the use of AI-generated content, as mentioned by Mr. Vinny, tech expert, suggests a more sophisticated cybercrime beyond Mr. Vicky's capabilities. The prosecution built its case on a shaky ground. There is no direct evidence linking Mr. Vicky to the creation and transmission of explicit images. Ms. Eliza claimed that images contained the content only Mr. Vicky know remains unsubtitled. And also, here point to be seen this that the technology expert also testified that the perpetrator had generated Eliza's personal detail from her social media interaction that concord the explicit content. If Mr. Vicky was willing or wanted to take any revenge, he could have gone to public or could have posted images to the publicly. Absence of direct evidence. The prosecution's case heavily relies on circumstantial evidence, which is not sufficient to establish guilt beyond the reasonable doubt. The Supreme Court in Sharda Bidichan versus State of Maharashtra held that the chain of evidence must be so complete as not to leave any reasonable ground for the conclusion consisting with the innocence of the accused. Character evidence. Character evidence was in the favor of Mr. Vicky, which has been provided by the Kartike and Dr. Anish. They have testified to his non-violent nature that cast no doubt on the prosecution's claim would have resort harmful action. Presumption of innocence. The presumption of innocence is a fundamental principle of criminal jurisprudence. In this case, Dharamdev Yadav versus State of UP, the Supreme Court held that presumption of innocence is a human right. Unless the guilty of the accused is proven beyond the reasonable doubt, he is presumed innocent. This principle applies on Vicky's case as well. Standard of proof. The standard of proof is a criminal cases beyond a reasonable doubt. In State of UP versus Anil Singh, the Supreme Court held that two views are possible on evidence abducted in the case, one pointing on the guilty of accused and the other to his innocence. The view which is favorable to accused should be adopted. In conclusion, I would like to conclude for this issue is Mr. Vicky is a minor of 17-year age with a clean record, has been falsely accused with the offense of cyberbullying based on prima facie circumstantial evidence. The prosecution case rests on weak foundation, a single traced IP address. We urge Honorable Court to consider all the facts presented. Mr. Vicky himself is a victim of cybercrime and his privacy has also been violated during the investigation. Along with that, counsel seek deep concern over how a 17-year-old minor was treated as an adult from day one of investigation. Counsel seek permission to address issue 2.
Yes, please.
Much obliged.
Issue number 2. Whether the age of Mr. Vicky warrants special consideration for him and should he be regarded as a juvenile or an adult in these legal proceedings. We represent Mr. Vicky, the 17-year-old appellant in this case. The lower court disregarded his age and vulnerability as a minor while convicting him of cyberbullying. This argument implies the importance of Mr. Vicky's age and urged the court to consider him under the purview of the Juvenile Justice Act 2015. As per Section 2 and Subsection 35, Mr. Vicky is a juvenile and should not be treated as an adult, even as per Section 15 of the Act. A juvenile offender between the age of 16 to 18 who has committed a heinous offense may be tried as an adult by putting him to trial under the criminal justice system. However, a juvenile offender can only be tried as an adult under the Act after the board, with the assistance of psychologist or psychosocial worker or other experts, has assessed the juvenile offender on the following: the capability of the juvenile to commit such type of heinous crime, his ability to comprehend the consequences of the offense committed, the circumstances in which the offense was committed. The board's responsibility is to recognize whether the offending child can commit a heinous offense and whether the offending child understands the consequences of the offense committed. The board must complete its assessment within 3 months from the date of the child being produced before the board. After the assessment, if the board concludes that the juvenile offender has committed the crime with the knowledge that and intention required to commit a heinous offense, then the board may order the transfer of the case to the children's court. Basis the recommendation from the board, the children's court may determine whether there is a need for trying the child as an adult under the provision of the Code of Criminal Procedure 1973 or not. If the children's court does consider that the child must be tried as an adult, then it shall pass appropriate orders taking into consideration the doctrine of fair trial and maintaining a child-friendly atmosphere. But during the investigation, there was no mention of the board nor the children's court. Also, as per the timeline, it can be seen that the investigation started on 14th of January and ended on 28th of January. That is, investigation lasted only 14 days. Vicky is just a 17-year-old child who has gone through a lot of things, and this can affect Vicky's life and his perspective towards the world and justice delivery system. Has created such a bad impact, such as a child treated as an adult during an investigation can experience a significant amount of emotion stress and even emotional breakdown. Age of child, younger children are more vulnerable to this negative impact due to their limited coping mechanisms. The severity of the investigation and the potential consequences will further influence the emotional toll on the child. Treating a child within the juvenile justice system allows for age-appropriate procedures that prioritize their well-being. Subjecting Mr. Vicky to the adult justice system would be a great injustice. Prisons are not equipped to address the specific needs of minor. He would be at risk of exploitation and further negative influence. Age as a factor in cybercrime. In the landmark case of R versus Smith, the Honorable Court recognized that age is a significant factor in cybercrime cases. Young individuals are more likely to be unaware of the consequences of their actions online. This lack of awareness should be considered when determining Mr. Vicky's liability. In conclusion, Mr. Vicky deserves the protection and guidance afforded by the Juvenile Justice Act. His age is a crucial factor in this case. Treating him as a juvenile offender allows for a more human and effective approach to justice. We implore the Supreme Court to acknowledge Mr. Vicky's age and consider him under the provisions of the Juvenile Justice Act. This decision would not only deliver a justice outcome for Mr. Vicky, but also set a precedent and can be an important reference for future cases where no future of the child should be risked by the treating him as an adult where it is not necessary. Respectfully submitted, counsel for Mr. Vicky. Issue number 3.
Council seek permission to address issue number 3.
Yes, please.
Much obliged. Issue number 3 states that whether the penalty imposed on Mr. Vicky is justified and legitimate. A sentence disproportionate to alleged crime. A 10-year sentence appeared predetermined and fails to consider the nature of alleged crime. While cyberbullying is a serious issue, the severity can vary depending on the content, intent, and lasting impact. There is no evidence in this case to suggest that cyberbullying reached the level warranting such a lengthy imprisonment. The punishment is not justified as Mr. Vicky is just 17-year minor who is investigated as an adult, treated as an adult, and sentenced of 10 years of imprisonment for cybercrime, which is indeed a heinous, but not all cybercrime are heinous. Each case has different gravity of crime and depends on circumstances. Some mitigating factors are age of the offender. Juveniles may lack of full understanding of all the consequences of their action in this digital world. Intent and impact. The intent behind the crime and the actual impact it has on the victim plays a crucial role in determining the severity. Considering Mr. Vicky's age and potential for reform, Mr. Vicky's age is a critical factor. At 17, his thought process and emotional response are still underdeveloped. Principle of Dole in Cap.
10 minutes are counted and kindly conclude both the issues in 5 minutes. You got it?
Your Honor, we wasn't able to hear. Council seeks request to please. Are we audible?
Team B2, you are not audible.
Not audible.
Uh,
Please turn on your mic.
mic is already on. Am I still not audible?
Am I audible to you?
Yes. Are we still not audible?
By the judges, you have given 5 minutes. You have to conclude within a 5 minutes.
Are we audible? May we continue with the issues? My lordships, are we audible?
Yes, you are audible now.
May we continue with the issues?
Conclude both the issues.
Yes, Your Honor. Council seek permission to address issue number 4.
Issue number 4. Whether Vicky's fundamental right of privacy has been breached in the investigation as his system was looked into without his permission and knowledge, whether the investigation should be set aside on the aforesaid ground. Right to privacy is recognized as a fundamental right under Article 14, 19, and 21 of the Indian Constitution. In the landmark case of Injustice, case Uttaswamy versus Union of India, the Honorable Supreme Court has held that privacy is an intrinsic part of the right to life and personal liberty. Juvenile Justice Act 2015 outlines specific procedure for investigating juvenile in India. But as we can see, the investigating officer is Kapil Sharma, is inspector. Rather, there should be the officer with special training. Along with that, Mr. Vicky was repeatedly asking that his Article 21 of the Constitution has been violated. The Indian Constitution under Article 21 guarantees the right to privacy as an intrinsic part of the right to life and liberty. This right safeguards individuals from unwarranted intrusion into their personal lives. Fairness and accuracy. Warrants require probable cause to be established, ensuring investigations are not based on mere suspicion. This promotes fairness and reduces the likelihood of errors. Evidence obtained illegally without a warrant when one was required may be excluded from court. Warrants ensure the evidence gathered can be used in court, leading to a just outcome. This case involved the arrest of the accused based on suspicion of possessing Sandalwood without a warrant. The search of his residence also happened without a warrant and Sandalwood was recovered. The Supreme Court has held in the case Param Shetty versus State of Tamil Nadu 2011. The arrest and search were illegal as there was no warrant or justification for them under the Code of Criminal Procedure. If the court condones such warrantless search of minors' devices, it sets a terrifying precedent. Imagine any teenager being a target of investigation without due process. This could have a chilling effect on freedom of expression and instill fear amongst young people who utilize electronic devices for communication and learning. Prayer. Adjudge and declare that Mr. Vicky is not guilty of the charge of cyberbullying and harassment, considering the circumstantial evidence, expert testimonies, and possibility of a hacking incident. Acknowledge that Mr. Vicky, being a minor of 17 years age, should be treated as a juvenile offender under provision of JJ Act, ensuring a more human and effective approach to justice. Set aside the harsh 10-year sentence imposed on Mr. Vicky as it exceeds the bound of reason and justice. Disregard the principle of proportionality in sentencing and fails to consider the potential for reform. Uphold Mr. Vicky's fundamental right to privacy, which was potentially violated during the investigation, and exclude any evidence obtained illegally. Order a retrial with due process followed, including procedure that consider the specific vulnerability of a minor. The court may also be placed to pass any further order which this honorable court may deem fit in light of justice, equity, and good conscience. For this act of kindness, the petitioner shall duty bound forever.
Respectfully submitted on the behalf of petitioner.
Okay, thank you, team B2. Now I request team A4 to present from respondent side.
Counsel seeks permission to present the case on the behalf of the respondent. Much obliged, Your Lordship. Counsel seeks permission to start with the facts of the case. Much obliged, Your Lordship. For the sake of brevity and convenience of this honorable court, the counsel for the respondent state the facts as follows. Mr. Vicky and Ms. Eliza, the appellant and the respondent respectively, are the students of Howard High School, Mali, in Uttar Pradesh.
You start with the issue. Because somebody was thinking about start with the red for the issue. Next, because one more red next.
Counsel seeks permission to start with the issue number 1. Much obliged, Your Lordship. Issue number 1. Whether Mr. Vicky can be held liable for cyberbullying and harassment endured by Eliza. Your Lordship, it is most humbly submitted before this honorable court that victim Miss Eliza has endured pain and agony of harassment by the act of the cyberbullying. Mr. Vicky's act of cyberbullying and harassment has shown her inner confidence and she suffered a significant pain of mental depression. The criminal act done by her friend created a fear in her mind, Your Lordship, and she is broken at such level that she has negatively affected her studies. Your Lordship, her parents are also in shock by witnessing what their daughter has to go through. Your Lordship, the mental pain and harassment endured by Miss Eliza must be taken into consideration while deciding the nature of the offense by Mr. Vicky. Your Lordship, Mr. Vicky knew about the consequences of his act and he was well aware about the pain and the discomfort Eliza would have to endure. Your Lordship, the harassment has no limits. The victim might be drawn to serious and unfortunate consequences. Your Lordship, thus the results of Vicky's pre-planned crime are serious and were known to him. Your Lordship, in the statement of Karthikeya, the statement given by the Karthikeya, mutual friend of Eliza and Vicky, must be noted here carefully. As he said, the friendship of Mr. Vicky and Miss Eliza was on worst stage after Miss Eliza had received an offer
take first step from university. Karthikeya also stated that Mr. Vicky has also applied to the same institution, but he did not receive any offer, which leads to a disagreement between Elsa and Vicky. The two persons who were once close friends and suddenly had an argument, they stopped talking to each other. All these incidents leads Mr. Vicky to create problem in her life and to harass Miss Eliza. The motive behind the crime is clearly the jealousy and the frustration of Mr. Vicky after breaking ties with Miss Eliza. Mr. Vicky, the appellant in the incident case, is liable under the following provisions. Section 354A IPC, that is sexual harassment and punishment for sexual harassment. Section 354D IPC, that is stalking. Section 509 IPC, that is words, gestures, or act intending to insult the modesty of women. In the incident case, by creating malicious images of Miss Eliza, the modesty has been insulted. Section 66 of IT Act 2000, punishment for identity theft. Section 66E IT Act 2000, that is punishment for violation of privacy. In the Ritu Police versus State, kindly refer page number 2 of the memorial given to you. The Delhi High Court had this persistent messaging, calling, and emailing the accused constituted stalking under Section 354D of the Indian Penal Code. The court emphasized that stalking includes online behavior that causes fear or distress to the victim and is punishable under the law. In the Vijay Kumar versus State of Haryana 2010, page number 2 of the memorial given to you. In this case, the Supreme Court clarified that the word outraging in Section 354A does not necessarily involve physical contact and include that outrage the word modesty of a woman. As per the facts of the incident case, the IP address from which the explicit and the malicious images were sent to the respondent was found to be of Mr. Vicky's system. These evidences against the appellant is a key factor of the case. All the circumstances and the evidences pointing the finger towards Mr. Vicky as the real preparator of those images. He is a real culprit and liable for the harassment and pain endured by Miss Eliza. The fact of the IP address must be noted here carefully. The IP address footprints are directly related to the hardware of the hardware system of Vicky, as it is a clear evidence that his system was involved in the said crime. May I counsel this commission to start with the issue number second? Much obliged, Your Lordship. Issue number 2. Whether the age of Mr. Vicky warrants special consideration for him, and should he be regarded as a juvenile or as an adult in these legal proceedings? Your Lordship, it is most humbly before this honorable court that by appealing to treat the accused as a juvenile should be rejected. Your Lordship, the accused must not be treated as a minor, as it will lead to grave injustice to the victim. Your Lordship, the accused must not let to take the undue benefits of law and provisions of Juvenile Justice Act. Your Lordship, the case of cyberbullying and online harassment have been increasing rapidly nowadays. Its consequences are dangerous for the victim and her family. Your Lordship, Section 15 of Juvenile Justice Act that deals with a preliminary assessment into serious offences by the board. Clause 1, in a case of heinous offence alleged to have been committed by a child who has completed or is above the age of 16 years, the board shall conduct a preliminary assessment with regard to his mental and physical capacity to commit such offence, ability to understand the consequences of the offence, and the circumstances in which he allegedly commit the offence, and he may pass an order in accordance with the provisions of subsection 3 of section 18.
Is this a heinous offense?
Your Lordship,
Is this a heinous offense?
Your Lordship, this must be treated as a heinous offense because the mental pain and agony and feel by
Which provision?
sections
Section 2.
3 to 33 of the Juvenile Justice Act defines a definition of heinous offences, and it clearly said as a offence offence having punishment having 7 years or more. 7 years or more.
In which of the section punishment is more than 7 years or more?
Your Lordship,
Under which the accused is convicted.
Your Lordship,
No doubt, indeed, Your Honor, there is no provision for the IPC which deals with the provision up to 7 years, but the mental pain and the agony endured by Miss Eliza is relevant and must be relevant here as 10 years of imprisonment given to Mr. Vicky. Your Lordship, as per the facts of the incident case, the statement of Dr. Anish that Vicky was very calm and mature of his age, this statement suggests that Mr. Vicky clearly knew about the nature and the consequences of his criminal act. This kind of pre-planned act of harassment against women is serious offense. As per the guidelines of the Juvenile Justice Act 2015, if offender is above age of 16 years and the offense is of serious nature, the offender can be treated as an adult. Your Lordship, Dr. Anish also informed that by going through Mr. Vicky's clinical report, he found that Mr. Vicky is short-tempered. So the statement of matured of his age must be considered relevant here as it shows Mr. Vicky knew the consequences of his act. Your Lordship, as per the parameters provided in the Juvenile Justice Act, Section 18, the serious and heinous offences must be treated as an adult, not a child. Your Lordship, kindly refer page number 4 of the memorial submitted to you. In Rajkumar Gupta versus State of Punjab, the Supreme Court emphasized that each case to determine whether the juvenile should be treated as an adult based on the severity of the offences. The court upheld the principle of Juvenile Justice Act will be recognizing the gravity of the offences. Your Lordship, in the instant case of the sexual harassment against a woman is a grave offence. So, as per the principles of Juvenile Justice Act, the appellant Mr. Vicky is rightly treated as an adult by the Honorable High Court. Your Lordship, counsel seeks permission to my co-counsel will represent each member of the much obliged, Your Lordship.
The council seeks permission to represent issue number 3 on behalf of the respondent. Whether the penalty imposed on Mr. Vicky is justified and legitimate. It is most humbly submitted before the Honorable Court that the penalty imposed on accused Mr. Vicky in the instant case is completely justified and legitimate. First, the mental harassment endured by Eliza must be considered. In the instant case, the victim, Miss Eliza, has gone through a very tough and critical situation. Her mental condition and thought process was badly affected by the criminal act of her own friend, Mr. Vicky. It is most humbly requested that Honorable Court should not ignore that the criminal act could have resulted in more unfortunate consequences where the victim whole life could be on the stake. As Miss Eliza, being a bright student and looking forward to study abroad with ambitious future in her mind, got a sudden shock and attack on her personal life is no less than a life-threatening attack. The penalty imposed on Mr. Vicky is justified. It is most humbly requested to the Honorable Court that in the instant case, the accused is treated as an adult, and the penalty and the punishment imposed is according to the nature and the graveness of the crime. Mr. Vicky knew the consequences of his act. He knew that by spoiling her social reputation and disclosing her private images, he can successfully hurt and harass Miss Eliza. It can lead to affect her study, her psychological state, and her whole life. The psychological harassment has no limits. It could have been ended in suicidal case or any other grave unfortunate result. The criminal act of Mr. Vicky was pre-planned with cold blood, knowing what he is doing. Mr. Vicky deserves the sentence he was awarded by the Honorable High Court. In Medha Kotwal versus Union of India 2014, the Bombay High Court held that mental harassment is as detrimental as physical harassment. It is most humbly submitted before the Honorable Court that sentence awarded to Mr. Vicky was based on various charges imposed on him, and the legitimacy of the penalty cannot be questioned as it is per existing law. The Section 66C of the Information Technology Act 2000. Whoever fraudulently or dishonestly makes use of electronic signature, password, or any other unique identification feature of any other person shall be punished imprisonment of either description for a term which may be extended to 3 years. Mr. Vicky created a fake account and liable for the 3-year imprisonment under this offense. Section 66E of IT Act, punishment for violation of privacy. Whoever intentionally or knowingly captures, publishes, or transmits the image of a private area of any person without his or her consent, under circumstances violating the privacy of that person, should be punished with imprisonment, which may extend to 3 years.
Actually, we have 5 minutes. Just to conclude your.
Council seeks permission to present the issue number 4. It is most humbly submitted before this honorable court that allegations of the biased investigation are completely baseless. The investigation authorities were completely free from any influence and working with all the fairness and in direction of finding the truth of the cases. It is most humbly submitted before the court that looking for Vicky's system to get evidence relevant to the case was necessary part of the investigation. The investigation authorities were working without any malevolent intention. The content in the system of Wiki could have been removed if authorities have taken the permission. The permission taking is a time-consuming process and it would defeat the whole purpose of justice and its investigation. To avoid any manipulation with evidences of the case, the authorities had valid and reasonable obligation to take the desired steps. But informing Wiki about investigation of system could have needed the possible manipulation with evidences. This would have defeated the purpose of investigation. As per the sensitivity of the case, it was a necessary step to dig out the truth and the investigation authorities did what was necessary. Breach of fundamental right of privacy in investigation procedure. It is most humbly submitted before the court that the fundamental right to privacy provided by the Article 21 of the Constitution is not absolute right. There are certain circumstances where the right can be revoked and breached up to some extent. As per the restriction imposed on the right to privacy in circumstances such as national security, public order, morality, and prevention of commission of crime. In the instant case, it is humbly submitted that as per the fact of the case, of Mr. Vicky was an important system of the Mr. Vicky was an important evidence of the case. His IP address was found involved in the commission of crime. So the parameter of right to privacy allows the investigation authorities to look into the system as system was not mere his personal property but also important evidence in the case. In PUCL versus Union of India, it was held that right to privacy is supplement to the security of the state involving versus the state of MP. It was held that right to privacy is not absolute right. In the end, I ask permission to present the prayer.
Yeah.
Wherefore, in the light of the facts stated, issues raised, authorities cited, and argument advanced, may this honorable court be pleased to. Mr. Vicky is liable for the cyberbullying and harassment endured by Ms. Elijah. The penalty imposed on Mr. Vicky is justified and legitimate. The order of the sentence awarded to Mr. Vicky is current and must be sustained. It is humbly requested there is no illegal breach of privacy in the instant case and request of appellant to set aside the investigation must be rejected and the judgment given by the Honorable High Court should be sustained. Pass any other order, direction, or relief that it may deem fit in the best interest of justice, fairness, and good justice. For this act of kindness, the prosecution shall be bound forever. Pray. Thank you.
Team B2. Do you want to rebuttal? Do you want the time?
Yes. Yes, Your Lordship, we are willing to do rebuttal.
You are not audible.
Yes, Your Lordship, we are willing to do rebuttal. Are we audible?
Team
Are we audible?
B2. You have time of 5 minutes. You have time within 5 minutes. You have to conclude. Okay. Sorry.
Are we audible? Council seek permission to start with the rebuttal.
Okay.
Council seek permission to start with the rebuttal.
Am I audible?
Yes, Your Lordship. Yes.
You have
Are we
stated
audible,
that,
Your Lordships?
yes, you are not audible.
We are not audible. Hello, hello. Are we not? Should we join again? Are we audible now? Your Lordships, are we audible now?
No,
No, no. उधर जाइए, अदर जल्दी करो. Your Lordship, from the other top. इसको mute करो.
आपने ये क्वेश्चन आगे किया था बिहेवियर जो है दोनों फ्रेंड्स थे उसके बाद उन्होंने एग्जाम दिया जैसी हुआ उसका प्रमोट ही हुआ ये आपकी अजम्पशन है या कोई हमें वो भी हमें और जो शॉर्ट टेम्पर क्लासिफिकेशन वो वहाँ कैसे
Are we audible, Your Lordship?
Just wait, please, Gurupati.
Are we audible?
Attempts of attempts those is not confusing. And IP address.
this case of circumstances
This case of circumstances plus IP address. Accounts
Are we audible? Your Lordships, we are.
It's done.
Your Lordships, we are audible.
no questions to team B2. Okay, you are done.
So, dear teams, we will announce the result within 10 minutes. So, wait for 10 minutes. Thank you.
is the